Court is on the record in City of Conneaut versus Gregory S. Ely, case number 25 CRB 398. At his initial appearance hearing on December 9th, 2025, Mr. Ely pled not guilty to one count of domestic violence.
Quick legal breakdown here. A fourth-degree misdemeanor domestic violence charge might sound minor, but it's anything but. Even at this level, it can affect gun rights, housing, employment, and future sentencing. This is the kind of charge that quietly follows someone for life. Would you have taken the plea offer if you were in his position?
It's a fourth-degree misdemeanor. Bond was set, and today we are scheduled for a first pretrial conference. Mr. Ely is present. He's accompanied by his attorney, Edith Jonas. Also present is Law Director John Lewis. Mr. Lewis, the court is in receipt of a pretrial report.
Thank you, Your Honor. The offer that's been extended to Mr. Ely today would be to plead as charged, with the parties then arguing the sentence. I discussed that offer with Ms. Jonas. Ms. Jonas indicated to me that she will be requesting that the court order a competency evaluation for Mr. Ely. Thank you.
And here's where this case takes a hard turn. Instead of negotiating sentence, the defense raises competency. That's not strategy. That's a red flag. In legal terms, this shifts the focus from what happened to whether the defendant can even stand trial.
Thank you, Ms. Jonas.
I'm going to have to, sir. This is the first opportunity I've had to speak with Mr. Ely. He does not have a telephone. His phone is the alleged victim's telephone number that I have in my file, so I didn't think it was appropriate to call her. I would indicate for the court that Mr. Ely says he is not having suicidal ideations today, but he was yesterday. So I would just ask the court to inquire to see if he's okay to walk out of the building, or if we need to call an ambulance to make sure.
This is one of the most sobering moments in the hearing. When defense counsel raises suicide concerns on the record, the courtroom energy changes instantly. Judges are no longer just referees. They're balancing public safety, mental health, and constitutional rights all at once.
That he doesn't do anything to harm himself.
What does that mean?
Which part?
I can't read.
No, I just want to make sure you're not going to hurt yourself.
I'm not. I took my meds today.
Okay.
I have a doctor's appointment today.
Okay. Did you take your meds yesterday?
I took them later at night before I went to bed.
Okay. Okay. So you're not having suicidal ideations? No? Okay. Thank you. Thank you, sir.
So are you entering an oral motion right now for competency?
Oh, I'm going to file I'll want a written file. Oh, for gosh sakes. I'll have a written motion for competency filed by the end of the day, sir. Yes, I'm going to ask for a continuance or at least a second pretrial to get that motion filed.
I mean, if you do submit an order or a motion and I issue an order, I mean, Mr. Ely's going to have to cooperate with that evaluation. So will that be done through your office?
I just spoke with Mr. Ely. He said, okay, so there's another issue that maybe we need to get on the table, but I think Mr. Ely's support system is the alleged victim, and I'm going to ask if the court or Mr. Lewis would inquire of Ms. Kathy Ely if she still wants the no contact order, because they showed up together at court today. That she's his support there. These two people back here are his only support system. So they came
to court together?
No, we were just sitting at the ice sheet.
Oh, they were sitting outside in the hall. But in either case, he has an appointment in Cleveland today. His ride for his mental health physician, et cetera, et cetera.
That's tomorrow.
Okay, the record will reflect that Kathy Ely, the alleged victim, is present in the courtroom. Ms. Ely, I imposed as a condition of your son Gregory Ely's bond that he have no contact with you. Do you wish to have that no contact condition remain?
No.
You would like that lifted?
Yes.
Okay. Okay. I guess in order to facilitate the evaluation, I will go ahead and, to ensure that the evaluation gets conducted, I will modify bond to remove the no contact condition between.
That right there is a massive decision. No contact orders are standard in domestic violence cases, even when the alleged victim objects. The court lifting it tells us the judge believes mental health logistics outweigh potential risk. But do you think that's the right call?
The defendant and Kathy Ely. Upon the submission of a competency motion, the court will review it, and if I find it necessary, I will grant it. Let me just ask, Mr. Ely, do you understand what is happening today? Do you understand the nature, what's happening? You've been charged with a criminal offense. Do you understand that? Okay. Do you understand what type of criminal offense it is?
It's a class 4 misdemeanor.
Okay. And what's the nature of the charge? What's the charge?
I think it was domestic violence.
Okay. And when you're on your medications, and I understand just based on the conversation we've had today, and then I understand from our initial appearance hearing on December 9th that you're receiving treatment at the centers in Cleveland, which is what I've ordered you to successfully comply with that treatment. Your prescribed medications, so when you're on your medications, are you able to understand everything, and you're able to assist with your attorney in presenting a defense to any of the charge?
At the moment, I'm going through a med change, and I think that's where a lot of this came from. They wanted me to try something different, something that would be less likely to be abused, and it's just not working out, and I'll have to tell them that either I would have to stop taking these or take the old medication that I was on.
Okay. You seem pretty lucid to me. Competency is whether you can assist in your attorney in presenting a defense to the case, and whether you understand the nature of the charge and everything like that. It seems to me like you understand. You're able to communicate well, and you're able to assist your attorney in presenting.
This is the legal heart of competency law. The judge isn't asking if the defendant is struggling. He's asking if he understands the charges and can help his lawyer. Mental illness alone doesn't make someone incompetent, and this exchange shows exactly how thin that legal line can be.
Defense in your behalf.
Yeah. So I've went through a couple competency hearings through this court, and the Jefferson court, and they all come out the same.
Was he found competent? Okay.
I mean, it's been a while. It's been quite a long time since we've had a competency hearing with Mr. Ely. So
if
I guess what I'm going to tell you, Ms. Ely, or Ms. Jonas, is that if you file a motion, it doesn't mean I'm automatically going to grant it. Based on what I'm hearing today, I don't think there's merit to it.
Why I'm concerned, I didn't know before today, and before speaking with him, when I ask him about it as well, I get the same thing. I'm on these meds. I used to be on medication and amphetamines. They changed them because they want me off amphetamines, and that the meds are, he's not taking it consistently. He told me yesterday he burned everything in his house. He was having suicidal ideations. He has nothing but the clothes he's here on today. And this was all just within the last 10 minutes of me trying to talk with him about this case.
Yeah.
I mean, he even said that these people told him to, when he said that I'm just going to kill myself, they said, whatever, do what you got to do. I mean, I'm not sure that.
Sure. Mr. Lewis, do you have anything you want to add to this?
Your Honor, I would just add, Ms. Ely, in the narrative of the police report, does discuss her feeling that a mental health evaluation would be warranted for Mr. Ely. and that she does discuss that with the officers in the narrative.
Well, while he was in the jail, Signature Health did evaluate him. I mean, so he was not pink slipped. I mean, a mental health evaluation is different from a competency evaluation. So, and the fact that he's currently receiving treatment at the centers in Cleveland, I mean, he's got a mental health provider. Perhaps they need to reassess him, but okay, here's what I'm going to set this case for a second pretrial conference. If a motion for competency is filed, I'll address it, but I'm not going to grant anything orally or otherwise today.
Final takeaway, no ruling today, no competency finding, but a lot left hanging in the air. The judge punts this down the road, buys time, and puts the responsibility squarely back on treatment compliance. This case isn't over, it's just entering its most unpredictable phase.
But I will set it for second pretrial, and I will modify the bond as I indicated. And I think Mr. Ely, and also to his family members who are here, Mr. Ely, you need to tell the centers that the medications aren't working, or you need to have them adjusted, and you need to explain to them what you're dealing with.
Well, believe me, they put me on a 7-day regimen, which I think they had a suspicion that this could happen.
Well, and they can provide that evaluation that perhaps your mom was talking about, and try to reevaluate you and provide treatment. Right now, I don't find you incompetent to stand trial. So, but we'll address that. We'll get this scheduled in about 30 days, the second pretrial. Okay, in the meantime, bond will be continued with the modification in the amount of $5,000 personal recognizance. You're ordered not to consume or possess alcohol or drugs. You are subject to random chemical testing, and you are ordered to successfully comply with any and all treatment recommendations at the centers in Cleveland. Okay? Anything further, Mr. Lewis?
No, sir, thank you.
Ms. Jonas?
Nothing, sir.
Okay, this matter is concluded. Mr. Ely, you go to the clerk's window, they'll give you a date and time for your next hearing, and then you'll have to sign the modified bond.
Yes, sir.
Thank you.